Hello and welcome to the Minimum Competence episode for Tuesday, September 10th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover Apple's $13 billion tax loss, Google's €2.4 billion antitrust fine, the Google ad tech trial, the buy, borrow, die tax loophole, and an IRS proposal to fight tax fraud scams. Let's remember, be glad you live in a world where there are Septembers, and read today's legal news. On this day in legal history, September 10th, 1846, Elias Howe was granted U.S. patent number 3640 for his revolutionary sewing machine. Howe's invention was a significant breakthrough, speeding up the process of garment production and forever changing the textile industry. However, Howe's legal battle soon followed as other inventors, including Isaac Singer, began producing sewing machines that closely resembled Howe's patented design. In 1854, Howe sued Singer, accusing him of patent infringement. The court ruled in Howe's favor, affirming that Singer's machine did indeed infringe upon Howe's patent. This victory not only solidified Howe's place as the rightful inventor of the sewing machine, but also secured him substantial royalties from Singer's machines, which were gaining widespread popularity. The case marked an important moment in patent law, demonstrating the power of legal protections for inventors during the Industrial Revolution. By enforcing his patent rights, Howe reaped financial benefits and ensured that his invention would be recognized for its originality. In a significant victory for the European Union's regulatory efforts, Apple and Google both lost high-stakes court battles related to antitrust and tax issues. The EU's Court of Justice upheld a €13 billion, that's about $14.4 billion US dollars, tax ruling against Apple, finding that Ireland's favorable tax treatment of the company amounted to illegal state aid. Apple had previously condemned the 2016 decision, but the court's ruling now forces Ireland to determine how to handle the recovered taxes. In a separate case, Google lost its challenge against a €2.4 billion fine for leveraging its dominance in search to prioritize its own shopping services over competitors, a ruling that reinforces the EU's efforts to regulate big tech. These decisions mark a major success for Margrethe Vestager, the EU's antitrust chief, as she prepares to leave her position after spearheading years of regulatory scrutiny on tech giants, including Amazon and Fiat. Both Apple and Google expressed disappointment with the rulings, but the decisions signal a continued regulatory clampdown on big tech in Europe, bolstered by new legislation such as the Digital Markets Act, which aims to prevent companies from favoring their own services over rivals. The ruling set a global precedent as other regulators around the world increasingly scrutinize Silicon Valley's market dominance. In the start of the Google antitrust trial in the U.S. Department of Justice argued that Google used its size and power to dominate the online advertising market, accusing the company of monopolistic practices. During the opening of the trial in Alexandria, Virginia, prosecutors claimed that Google controlled both sides of the ad tech ecosystem by eliminating competition, acquiring rivals, and locking in customers. Google's actions allegedly stifled competition in a market handling over 150,000 ad sales every second. Google's attorney, Karen Dunn, dismissed the case as outdated, comparing it to relics like BlackBerrys and iPods. She argued that Google's tools now work alongside competitors and that the digital ad market has shifted, with major players like Amazon and Comcast providing significant competition. Google's defense echoes its arguments in a recent search monopoly case, which it won. The Justice Department seeks a ruling that could force Google to divest key ad tech products like Google Ad Manager. The trial will continue for several weeks before a ruling is issued by the U.S. District Judge Leonie Brinkema. This case is one of several recent efforts to challenge big tech monopolies, with similar cases against Meta, Amazon, and Apple also underway. In a piece I wrote for Forbes, and with apologies for the upcoming double dose of me today, I delve into the tax loophole used by the ultra-wealthy known as the buy, borrow, die strategy. This tactic allows the wealthy to use highly appreciated assets as collateral for loans, giving them access to large sums of money without triggering taxable events. While some propose taxing loans at disbursement, I argue that a better approach would be a repayment realization rule, where taxes are applied when these loans are repaid, aligning more closely with traditional tax principles. Taxing at disbursement could open the door to various tax avoidance strategies, such as using offshore lending or taking out smaller loans to stay under tax thresholds. Additionally, taxing loans at the time of issuance could complicate valuations of illiquid or hard-to-value assets, making enforcement very difficult. A repayment realization rule, on the other hand, would ensure that taxes are triggered when wealth is actually monetized to repay the loan, addressing these loopholes. This approach would also reduce the risk of manipulation through rolling over loans or making small repayments, as each repayment would be taxed proportionally. While there are challenges, like preventing double taxation, this proposal offers a more effective solution to ensure the ultra-wealthy pay their fair share of taxes when they access their wealth. And it's Tuesday, so it's Column Tuesday, and in my column this week for Bloomberg, I propose the creation of an IRS-managed encyclopedia of tax fraud to help taxpayers spot scams early. While some fraudulent schemes are so obvious they're easy to recognize, others are packaged cleverly as legitimate tax strategies, making it difficult for the average person to tell the difference. Although the IRS publishes resources like the so-called Dirty Dozen list of frauds, these are often too technical or hard to locate, limiting their usefulness. I suggest an almost Wikipedia-style online database maintained by the IRS that offers clear, plain-language explanations of fraud schemes, real-life examples, and the warning signs people should look for when receiving tax advice. This would allow taxpayers to identify potential scams before becoming victims or unwittingly participating in fraud. It would also explain the consequences of engaging in fraudulent activity, serving as a deterrent. By compiling this information in one place, the IRS could better protect taxpayers and safeguard vital tax revenue, making the job of scam artists much more difficult. My aim is to create a first line of defense for taxpayers as fraud schemes become increasingly sophisticated. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, rest in peace, Lord Vader.